Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, from time to time we do talk about self-defense laws here in Washington State, and most routinely we talk about the defense of you yourself. Rarely do we talk about defending others, but I think today is a good opportunity for us to do just that. So let's spend a few minutes today and talk about, can I use lethal force to protect someone else in Washington State? Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button down below. If you want to stay up to date on issues related to your Second Amendment rights, go ahead and click the subscribe button down below. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming. That's how we're going to make sure that we get our videos out to more lawful and responsible gun owners like yourself. Okay, so the topic for today is, can I use lethal force to defend on behalf of somebody else? Can I use deadly force to defend somebody else? Now, let's take a step back and let's start with our baseline rules that we always want to talk about when we're talking about self-defense in Washington State. Under RCW 9A.16.020 subsection 3, we can use any reasonable, necessary, and proportional force to defend ourselves, including and up to lethal force under RCW 9A.16.050, so long as we are in imminent threat of death or serious bodily injury, or if a felony is being committed upon us. Now, that is one scenario that we talk about quite frequently. What if you are subject to an attack? You know, the scenario that we don't talk about as much, and candidly, when you think about it, there's a much higher likelihood that you may encounter this, is what if you encounter somebody else who's being unlawfully attacked? How much force do you get to use in those situations? Well, when we carefully pay attention to the exact words of the statutes that give us the legal authority to use force in our defense, we actually see, for example, under RCW 9A.16.020, subsection 3, the following language: the use or attempt or offer to use force upon or toward the person of another is not unlawful in the following cases. 3, whenever used by a party about to be injured or by another lawfully aiding him or her in preventing or attempting to prevent an offense against his or her person, or a malicious trespass or other malicious interference with real or personal property lawfully in his or her possession, in the case that the force is not more than is necessary. And kudos to the Washington State Legislature for writing such a clear and concise statute. But in a nutshell, we get to use any necessary, reasonable, and proportional force to defend ourselves or somebody else that's in our presence. It's right there in the statute. It specifically states that the use of force is not unlawful whenever used by a party about to be injured or by another lawfully aiding him or her. So yes, under RCW 9A.16.020, we have the legal right to use force to defend another person. Now, it says right here in the statute, as it says everywhere in RCW 9A.16 when we're talking about self-defense, is that the force we use always has to be proportional. That is, we cannot use disproportionate force. So, if we know that we can defend another individual by the use of lawful force, if they are threatened with imminent threat of unlawful force against them, what does it take for us to be able to use lethal force? Well, the very statute that gives us the authority to use lethal force also outlines when we can use lethal force to defend a third person. RCW 9A.16.050 specifically states, homicide is also justifiable when committed either 1. in the lawful defense of the slayer or his or her husband, wife, parent, child, brother, or sister, or any other person in his or her presence or company, when there is reasonable ground to apprehend a design on the part of the person slain to commit a felony or do some great personal injury to the slayer or to any such person, and there is imminent danger of such design being accomplished. And it also provides us with an opportunity to use lethal force, 2, in the actual resistance of an attempt to commit a felony upon the slayer in his or her presence or upon or in a dwelling or other place of abode in which he or she is. So if you are invited into a guest's home and it is being burglarized, do you have the right to use lethal force in that situation? You arguably do. So as you can begin to see, when we take these baseline rules, reasonable, necessary, and proportional force under 9A16020 subsection 3, lethal force only if we're in imminent threat of death or serious bodily injury under 9A16050, we see that the same standard applies to what we perceive as happening with that third person. So for example, let's talk about some real life examples here. Example number 1. You see a woman who is getting her purse snatched, and at the point that you get there, the purse has already been successfully snatched. Now, there was a robbery ongoing, but at this point, it's a purse snatching. Do you have the right to use force to defend her property? You most certainly do. Do you have the right to use lethal force at this point? No, you don't. Why? Because nobody is in imminent threat of death or serious bodily injury. And certainly there may have been a brief moment during the snatch where she was the victim of a robbery in some ways. That threat has ended the minute the robbery is fait accompli, and we are now in the escape phase. Take another example, though. You discover a woman who is being sexually assaulted in a park. Well, now, here's the thing. She has a felony that is being committed upon her. She is absolutely in imminent threat of serious bodily injury, and candidly, she could be in imminent threat of death. So, knowing that she is in imminent threat of death or serious bodily injury, do you have the right under RCW 9A16050 to use lethal force to defend her? The answer is yes, you do. Now, there is a third scenario permitted by statute in which we could theoretically find ourselves where the use of lethal force would be justifiable. The scenario here is you're driving down the freeway, you see a traffic stop, but then you realize that the driver of the car stopped and the trooper are rolling around on the shoulder of the freeway. There is an ongoing fight, and the trooper now is in serious risk of being disarmed and possibly killed with his own weapon. Believe it or not, RCW 9A.16.040, specifically subsection 1C, actually addresses this very instance, and that is what happens when we come to the aid of a law enforcement or police officer, because there is a statutory authority for us to deploy lethal force in that situation as well. The statute specifically states, homicide, or the use of deadly force, is justifiable in the following cases. Subsection C. When necessarily used by a peace officer, meeting the good faith standard of this section, or a person acting under the officer's command and in the officer's aid. So in that situation where we have an officer who is in distress, who themselves is potentially facing the imminent threat of death or serious bodily injury, not only do you have a statutory authority under 9A16020 subsection 3 and 9A16050, you also have statutory authority to use lethal force under RCW 9A.16.040 subsection 1C. Now, let's take another step back, though, and take a bigger picture look, because what I have done now is I have explained to all of you what you have the right to do. But as we talk about all the time at Washington Gun Law, sometimes it's about what you should do. And sometimes what we have the right to do and what's the right thing to do are actually different answers. And we have to recognize that when we start deploying lethal force ourselves, we open a whole nother can of worms. Take, for example, how about Mr. Hero Delivery Driver Guy? For those of you who've been watching the channel, you know about this hero. Well, he decided it was necessary to hold a person at gunpoint so the police could arrive so he could explain why he was in a verbal altercation with a woman that he didn't know who it was. Now, had some other driver come upon Mr. Hero Delivery Guy, not knowing the backstory, and seeing him hold another person at gunpoint, could that individual suddenly believe that our would-be victim here was actually in imminent threat of death or serious bodily injury? The answer is yeah, they could, and Mr. Hero Delivery Driver Guy could have been potentially shot, and with legal justification, by a passing motorist. And so what I hope this illustrates to you is how there is oftentimes a significant difference between what we have the right to do and doing the right thing. Listen, you may have more questions about the defense of others or anything related to your self-defense rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.